All right, joining us this morning is Bayan Muna Chairperson, Attorney Neri Colmenares. He's part of the group who filed the second impeachment complaint against Vice President Sara Duterte. So, Attorney Colmenares, let's talk about this from a purely legal point of view and the rules of the House and what the Constitution allows. So, the Vice President filed for a dismissal, claiming that the fourth impeachment complaint, that was the one that was passed to the Senate, should be dismissed because it is, in their words, void ab initio. It violates the 1-year ban rule under Section 3, Article 11 of the 1987 Constitution, which explicitly prohibits the initiation, not the filing, initiation of more than one impeachment. Attorney.
Yeah. Yes, Karen, thank you. Yes, and the Constitution says no impeachment proceedings shall be initiated against the same official more than once every year. Notice impeachment proceedings, not complaint. The first question is, when is a complaint an impeachment proceeding initiated? According to the Constitution, jurisprudence, and the rules, it is initiated if, one, it is referred to the Justice Committee, or two, if the articles of impeachment are signed by 1/3 at least of members of the House. So many were surprised where they're claiming that, because as far as everybody is concerned, there's only one impeachment proceeding initiated now, and that is in the Senate. So where is this more than 3 impeachment proceedings coming from? Their allegation actually, Karen, stems from the fact that 3 impeachment complaints were filed with the Secretary General, and the Secretary General failed to transmit it immediately in violation of the House rules. So basically,
But
they're
not
claiming,
the Constitution. But not
well,
the Constitution.
they're claiming that it's against the Constitution, but if you look at their answer, it only means that the SecGen violated the rules by not transmitting it immediately. So in the end, of course the prosecution will say, does that violate the Constitution? That's the first thing, because the Constitution didn't say what immediately means. Now we go back to the forthwith issue, and secondly, why should the taxpayers, the Filipino people's cause of action against a corrupt public official, for example, be compromised merely because the SecGen, failed to do his duty, if it is true that the SecGen failed to do his duty? So I think the 1-year bar rule is going to be dismissed by any court, including the Supreme Court, because there is, as far as everybody is concerned, there is only one impeachment proceeding initiated as of now, and whatever, the SecGen committed during the filing of the impeachment complaint is but a mere violation of the rules of the House.
Okay, so Attorney, balikan po natin, because this is the fourth impeachment that has been sent to the Senate. Yung impeachment complaint against former President Joseph Estrada. Now, there also wasn't just one complaint. I remember were there 2 or 3, but in the end, the House then consolidated the complaints. Is that correct? You remember?
Correct. Yes.
So, kinonsolidate nila ang complaint at naging isang complaint na lang yun na ipinasa sa Senado. Ito
Yes.
kasi, the first complaint had 70 plus signatures, right? Wherein Laila de Lima was a spokesperson there. And then there were too many articles of impeachment. Diba? Ang daming articles sa una. Sa second, nandun po kayo, ilang articles ang nandun?
Isa lang na, well, there is only one act, the 125 million and the 612 million confidential funds. There's only one.
Then may pangatlo, iba pa yon ang nag-file.
Yes, there is
Okay.
another complaint filed with the Secretary General.
So it's this fourth complaint that was signed by the majority of the members of the lower house, whose first signature was Representative Sandro Marcos. Ang tanong, bakit hindi na lang, attorney, kinonsolidate yung 4 na complaint yung tulad ng ginawa kay dating Pangulong Joseph Estrada. Parang
Wala.
ang nangyari, the three complaints were ignored. The Secretary General did not take action and only took action with a fourth complaint. Ba't di na lang pinagsama?
Yes. Well, actually, the fourth complaint contains almost all of the grounds or acts mentioned in the first three impeachment complaints. So basically, what probably the members of the House did was to put in all the complaints from the three and consolidated it into an article of impeachment and transmitted it to the Senate
Oo.
rather than refer it to the to the Congressional Committee on Justice. So yeah, they practically consolidated. I see in the fourth
And they did
impeachment.
not announce. They did not
Pardon?
announce the consolidation.
Well, I don't know if no, I don't. I didn't hear if they announced it,
Yes,
but
they did
that's
not.
not a requirement. That's not a requirement for them. Uh, Whatever their basis was, the fact is more than one third signed it, and even the three impeachment complainants, at least the two impeachment complainants, the members of the House who endorsed the impeachment complaints, the first and the second, also signed the articles of impeachment. So in the end, yeah, I guess the 1 year bar is a very strange argument because everybody knows, even the senators, I think, because some of the senators there have been through impeachment complaints before under Gloria Arroyo. They would know that there's only one impeachment proceedings. That's what the Constitution says, not the
Or, or
number of complaints.
Or is it precisely the reason why the impeachment complaint, the first, second, and third, was not acted upon? In other words, it was submitted, but the House technically did not act on those.
Well,
Is it
I don't. Yeah.
primarily because of the 1 year ban? In other words, do you think the House leaders waited for an impeachment complaint that was more concise, more solid, more firm? Do you believe that's why? Because you also ask the question, why wouldn't you act on a complaint? Is
Yes.
that
Well,
even allowed?
yes. Well, actually, we consider our impeachment complaint, the second, is very
Yeah.
solid, very firm, and only concise, very concise because it focuses on one of the strongest cases. I don't know what the reason of the House is, and if there was any reason at all where the Secretary General failed to transmit it immediately, but he's in the rules of the House, Karen, the SecGen is we don't file stuff in the SecGen. We don't file a bill there. The SecGen doesn't receive anything from us. So he is always bypassed in the entire process, only in this impeachment complaint. Because a bill or a resolution, we will file it with the bills and index in the House.
Hmm.
So it's not really clear what the SecGen's role is. When do you transmit? So I guess that's the question of the vice president. But again, going back to the Constitution says only one impeachment proceeding shall be initiated, and the fact that there are three complaints filed before, or four, or even 10 doesn't matter because that's what happened with Gloria Arroyo before, when when three or four impeachment complaint with Attorney Lozano always filing the first. In the end, though, there is one impeachment proceeding initiated, even if there were four impeachment complaints filed. So this is an old argument being raised by the vice president, which has already been resolved by the Supreme Court.
No. So I think what's important for the viewers to realize is the 1 year ban covers impeachment proceedings.
Yes,
Not,
only one.
yes, but you can have ordinary citizens file
Yes,
an impeachment complaint on their own. But if it does
yes,
not become an actual case that is sent to the Senate, it is
yes.
for just a complaint.
Correct. Yes. And if you listen to the argument of the vice president, then basically, uh, I guess they can always claim that they can file an impeachment proceeding against the Vice President Sara Duterte, like the case of Attorney Lozano, and then claim that everything else after the impeachment complaint of a pro Duterte supporter, for example, already precludes the others from filing, which is not really correct because the Supreme Court said no. Even if somebody filed an impeachment complaint, kasi yung kay kay President Gloria Arroyo, nagfa-file yung isang supporter niya ng impeachment complaint to preempt the others. Kaya to avoid that, even if there are 4 impeachment or 5 impeachment complaint, as long as there is no impeachment proceeding initiated through the transmission of the articles of impeachment to the Senate, then there is only one impeachment complaint.
Okay. Now, the next question is, so the vice president, her team filed for dismissal to the impeachment court, correct?
Correct.
Right. So this was actually her response, right? So
Yes.
the vice president is compelled to answer, and this was actually her response. The question now is a matter of the 20th Congress. So by June 30, that is the end of the 19th Congress. Let's talk in legal terms first, ha?
Yes,
Walang
yes.
unang opinion. Yung
Yes.
June 30, can the senator judges already decide on the dismissal or non-dismissal on June 30? Or at this point, they lack the time, and it is the 20th Congress who will respond to this dismissal.
Whether or not they lack the time, we don't know. But we have always been pressing that the Senate impeachment trial can convene today because the issues have been joined.
Yes. Uh-oh.
So
But they're
they
not
can convene
convening.
today,
Uh-oh.
and if they feel that they will dismiss it, of course that's their decision. But if they feel that it will traverse transcend or go to the next Congress, then that's their decision. But the fact is, I don't see any reason or ground why they will dismiss it because, as I mentioned a while ago, the 1 year bar rule is for
Yes.
me an absurd argument.
I know, but then this is beyond already logical reasoning. I mean, we've already seen it, Attorney Colmenares. We've
Yeah.
seen senator judges during the 19th Congress take their oath as senator judges, and yet, no less than Senator Bato de la Rosa filed or motioned for, not filed, he motioned for a dismissal after he took his oath as a senator judge. So
Yes, that's
let's go
correct.
beyond reason. Wala na tong
Yes.
reason. Wag na lang
Can it
reason.
transcend?
Wag na.
Can it
No more
go to the
reason.
next Congress?
This
What is the
transcends
legal?
reason. Oo.
Yes,
So,
I
ang
think
tanong,
yes.
oo. Because if this transcends to the next Congress, if the 19th Congress does not act on the Vice President's petition, no, for the dismissal, the 20th Congress has to. And the
Yes.
incoming 20th Congress has more supporters of Vice
Yes.
President Sara Duterte. There is
Yes.
already a Duterte bloc
Yes.
of a bigger
Yes.
number.
So
Yeah.
the
So
legal.
ang tanong, pwede ba ma-dismiss pag pinagbotohan to?
For me, the pinagbutohan in the next Congress, you mean?
Oo,
Well, it
kasi
can.
ang
Yes, it
nangyari,
can.
di ba, yun ang petition niya. So
It can.
you will have an ally, a supporter, who will say, let's take up this petition and let's take a vote.
Yes. Well, the senators can decide, but for us, the Constitution is clear. The Senate impeachment court must try the impeachment case. And I don't think an outright dismissal will be that because it's the word is try. And they're the only one, the sole authority to decide an impeachment complaint, Karen. And if they're going to not try it, but just dismiss it outright, for me, that will violate the constitutional provision, not only giving the Senate the sole authority to try an impeachment case, but also the Filipino people's constitutional right for accountability. Ang hinihingi lang naman dito, anong sagot mo sa Mary Grace Piatos? Totoong tao ba ito? O 125 million in 11 days? Yun lang naman, sagutin mo. Which, by the way, she didn't answer those factual allegations in her answer. So I think, of course, in the end, it's the senator judges who will decide. But for me, an outright dismissal will be in violation of the constitutional provision that they're the only sole authority to try and decide impeachment cases, because that's not really trying. They didn't even know the facts yet, and they're going to dismiss it outright. For me, is a sign that that the accountability mechanism of the Constitution did not work. If that were the case.
Okay, because no less than Senate President Cheese Escudero has said that there are, and I quote him, there are no limits to the Senate's power in the impeachment trial. So ang sabi ni Senate President Escudero, walang limitasyon ang impeachment court kaugnay ng pwede o hindi namin pwedeng pagpasyahan. He says, he cites the 1987 Constitution. The Senate shall have the sole power to try and decide all cases of impeachment. So, ang ibig sabihin dito, pwedeng acquit, pwedeng convict, pwedeng dismiss.
Well, para sa akin, acquit or convict ang ano diyan, ang sagot, no? Dismissal para sa akin is not trying in the sense that we believe, no? So kami na complainants, we will always assert the Constitution is clear. Try it. Dismiss it outright, then where is the trial there? We didn't even know what happened to Mary Grace Piatos. So we will assert that it has never been done before, the Senate Impeachment Court dismissing an impeachment complaint. But if they do so, of course we will oppose it, and we believe that the Constitution is on our side, Karen.
Yeah, but then the conduct of these senator judges is also, it's also the first that we've seen. I mean, during the impeachment trial of former President Estrada, even the late Supreme Court Justice Renato Corona, you had senator judges at least trying to appear impartial.
Correct.
The senator judges are shameless now. They're shameless. Senator,
Yes.
I mean,
Yes.
seriously, Senator
Yes.
Robin Padilla has openly pledged to defend the Vice
Yes.
President, who is an accused in this matter. But
You know,
it's
Karen,
different. It is so different today. It's
Yeah.
beyond reason.
The remand question, did you violate the 1 year bar or etc., violate the Constitution? That was asked in the Corona impeachment trial, and I was one of the public prosecutors there. That was asked in the first sessions of the impeachment court. But the one who asked it was Justice Cuevas, the defense, not the senator judges. So we had to answer in front of the impeachment court that it didn't violate the due process rights of the respondent, it didn't violate the Constitution. So my point is, not only who questions it, it usually is the defense, not the judge. But second is, they need not have remanded it even to the House, because they could have tried it right there and then on the first day of trial, they could ask those questions. But in any case, you're right. That's very strange action on the part of the Senate to return merely on the basis that they want to know whether the House thinks it did not violate the Constitution. So but now that I'm arguing that now that the vice president has already given her answer, then the impeachment court can even convene today and rule and of course conduct the trial, because there's no reason why, because the Senate, as probably mentioned in many of
Yeah.
your programs
It's sui
already,
generis.
yeah, it's not only sui generis, but the legislative function of the Senate is not cannot be imposed on the impeachment court. The rules even of the Senate says once impeachment court is convened, trial shall forthwith resume, and then it shall continue day to day until judgment has been rendered. So it doesn't mean even if you're sine die, if the judgment
Yes.
has not been rendered, then you continue doing it. And they are still the Senate impeachment court until now, and they can hear it now until June 30 if they want to, but they cannot say that, oh, we're recessed, so the impeachment court dies with the recess.
That's a good point. Actually, that's what they're saying through their actions, right? That the
Yes.
impeachment court dies with a recess of
Correct.
the legislative schedule.
Yes.
with it. Yeah,
In
that's
fact, in the rules,
through their
sorry.
actions.
In fact, in the rules, Karen, it says that at 2 p.m. in the afternoon, the Senate rules, the impeachment court shall hold trial and the legislative session of the Senate are suspended during trial. So the rules of the Senate actually divided the legislative function and the impeachment function. And this is, note, Karen, legislative sessions, if any, shall be suspended, meaning to say it is also possible that there are no longer legislative sessions and yet the impeachment court continues. So the vision of the Senate, the rules, is that you continue until judgment is rendered because an hanging impeachment trial is not good for the Filipino people. It's not good for the stability of the country. So the impeachment rules and I'm sure the Constitution actually believes that it must be continued until judgment is rendered rather than it is dismissed because there's a recess or an adjournment on the part of the Senate.
Okay, so my last question is, do you believe at this point this Senate is already violating so many provisions of the Constitution when it comes to impeachment trial?
Yes, the issue forthwith. The second is return to the House. It's not trying. Returning is not trying. The Constitution is clear. Try and decide forthwith. So they've all violated that. And for me, that if you go to the Supreme Court later, I'm sure we'll win that case. But we don't want to go to the Supreme Court now. We leave it to the Senate to decide for now, so that at least we can salvage the accountability mechanism here and make sure the question of the Filipino people is simply this. Saan mo ginastos yung 612 million? Sagutin mo lang yan. Totoo bang tao si Mary Grace Piatos? Even in her answer, she did not answer that. So we're waiting with bated breath how the Senate impeachment trial will be pursued so that these questions of the taxpayers can be answered.